Hello, ladies and gentlemen. My name is Piotr Nowaczyk, and I have the pleasure of meeting you virtually in this unusual time. To be honest, I would much prefer to see you all face to face, to give my friends a hug, to give my colleagues a handshake and talk over current matters over a cup of coffee. However, these times only allow for e-conferences, which has its upsides and downsides. First of all, I'd like to congratulate Mr. Vladimir Khvalei, the president of the Nowy Tomyśl Chamber of Commerce Court of Arbitration, for his courage and organizational skills at a time in which some of the major conferences have been cancelled, such as the session of the ICC Arbitration Commission and the ICCA conference, as well as the annual International Arbitration Days held by the International Bar Association. Mr. Khvalei, on the contrary, did pull the trigger and did not cancel the conference. We're doing it as best we can this year. I'd also like to thank the local authorities who have been with us for the past dozen or so years, including the current President of the Republic of Poland, who was also among the speakers here in Nowy Tomyśl, as well as the Starost of the Nowy Tomyśl district, Mr. Wykoński, as well as Senator Rybicki. Both of them have been die-hard fans and generous sponsors, while also providing us with spiritual and moral aid, and most of all, providing it to President Khvalei and all his endeavors. Arbitration conferences are abundant all over the world. I get to be invited to one or two of them every week. Sadly, some of them feature the same topics repeated ad nauseum as to the efficiency and universality of arbitration. This year, however, we decided to go against the grain while speaking on arbitration. We know that Poland struggles with arbitration, and we should consider some of the reasons for it, and the fact that the number of arbitration cases are few and far between, that their value has dropped, that Polish arbitrators are appointed to oversee such cases less frequently. The projected revenues are not as high as they used to be, and we also failed to land some of the major disputes which are redirected to international institutions from outside of Poland, while there are not many cases being landed by Polish companies which feature foreign stakeholders. I think we should probably have much more said about that from the impressive list of our guests. As usual, we have invited speakers from a dozen or so countries, alphabetically speaking, from Azerbaijan, Belarus, the Czech Republic, Russia, Romania, Hungary, Ukraine, and last but not least, Poland. We will also have speakers from Lithuania, Moldova, and Serbia. We're still waiting to receive their presentations. Ladies and gentlemen, opening this arbitration session, I should probably begin by stating the current state of affairs in Poland. The situation could be better. Things used to be better off. And why are they so poor at the moment? I think we should give it a few minutes of consideration. We have had modifications to our arbitration law pretty recently, and the multi-instance cycle of control of arbitration verdicts has been flattened, along with the establishment of specialists courts of appeal to hear cases on reversing arbitration court verdicts. So we should probably welcome this change. However, and it's a big however, this change is 10 years overdue, to say the least. In 2005, when the Civil Code was being modified, we should have implemented changes that would revolutionize our system, and would have us lead the pack ahead of Austria, Bulgaria, Romania, and other jurisdictions that were postulating the same changes at the same time. Sadly, while those countries did implement those changes, we have not until recently. Losing our appeal and attractiveness, we cannot boast our competences, our swiftness, our efficiency when compared with other countries. So far, Poland has failed to adopt the 1965 Convention on the Settlement of Investment Disputes, the ICSID, so we have been overlooked in any investment disputes settled within the ICSID system. Some Polish lawyers are even oblivious of the fact that since we failed to adopt the ICSID conference, our arbiters cannot act as arbiters, settling disputes between other countries. So we will not be appointed as individual arbitrators or presiding arbitrators in these cases. On top of that, we have had the whole ACMEA verdict kerfuffle. So in short, we have revoked some bilateral agreements on investment protection with other EU member states. The number of these cases will be on the decrease. Unfortunately, we will no longer have Polish arbitrators ruling in investment disputes within the EU. And still, there are also some legal events related to ICSID. Out of the 60 BITs we signed, some of them included ICSID arbitration as one of the options, which I personally consider unethical. For if we fail to adopt the ICSID convention, then why do we include or list ICSID as one of the arbitration methods? It is just as misleading as if we handed out our business cards with a fake address of our company. When it comes to arbitration, there is a strong opposition in Poland. Arbitration is frowned upon by state authorities, by the General Counsel to the Treasury, which has recently been renamed the General Counsel to the Republic of Poland, sees arbitration as a costly tool and an inefficient one in terms of dispute solving. So wherever it can, it encourages businesses, especially state-owned companies, to depart from arbitration. So major players in Poland, such as the Polish National Railways or the General Directorate for National Roads and Motorways, strike out arbitration clauses from their contracts, even those that were concluded before. So the number of arbitration cases, especially in construction, will be few and far between. The General Counsel to the Republic of Poland also features new Court of Arbitration, which coaxes any state entities to seek dispute resolutions right there and only there, which will lead to the further diminishment of the number of permanent arbitration court cases. There has been a serious dispute between the Ministry of Justice versus judges in Poland on the different stages in the appointment of Supreme Court judges and the National Council of the Judiciary. In general, Poland has been criticized for failing to comply with certain judicial standards by Western states, and this whole confusion, on the one hand, should favor arbitration, because given our ailing judiciary, where everybody is well aware of the existent collapse of the Polish judiciary, a collapse that is most visible in Warsaw, where courts of first instance take as long as several years to pass a verdict, while courts of appeal take a year and a half. So in the capital city of Poland, where you wait for over 6 years to have a ruling in your case, in 2 instances, arbitration should be flourishing as an alternative solution. But for it to flourish, for it to blossom, we should massively propagate and promote arbitration as a methodology, use proper marketing devices, publicity strategies, appeal directly to the business sector rather than the lawyers who represent them. Arbitration conferences should be targeting business itself rather than the academic milieus and student bodies. Paradoxically speaking, the confusion around the Polish judiciary has backfired on arbitration. The more bad press Poland receives abroad as a country that has violated the rule of law, the more difficult it is to persuade a foreign investor to recognize Polish law as the governing law in a contract, or to have potential disputes resolved in Polish by Polish lawyers and Polish arbitrators. In short, the more difficult the situation of the Polish judiciary, the more challenging our situation as Polish arbitration institutions. Furthermore, there are glaring gaps in our marketing and publicity. Our arbitration bulletin, which I had the honor to be the founding editor of in 2006, and which flourished because it was published as a bi-monthly with a circulation of 26,000 copies for every registered attorney at law in Poland, which was considered to be a typo by my foreign colleagues, who thought that I may have added 1 zero too many, because at the time the most popular bulletin was the Swiss ASA, which had the circulation of as little as 3,000 copies. So, as I said, our bulletin was very popular. It had almost 30 printed editions until it disappeared from the market, although recently there have been attempts to resuscitate it in the electronic form. Hopefully it will be successful as a revived publication. I wish all the best to its current editors, and I hope that it will generate comparable circulation numbers as previously. Unfortunately, the leading Polish arbitration institutions failed to publish their stats for the simple fact that they are a pitiful sight to behold in comparison to the numbers generated 10 years ago. Without going into details, the number of cases, the arbitration cases in Poland, was cut in half, to say the least, and that is in comparison with the leanest years in history. So there is a paradox of sort, ladies and gentlemen. More and more lawyers are into arbitration, more and more students wish to specialize as future arbitrators, but the number of arbitration cases has been dropping consistently, so we should all take pause and think about it. How come that the Viennese elocution contest Vismut attracts as many as 7,000 contestants every year, where my calculation go to show that around Europe there is not even 7,000 arbitration cases continent-wise, and that's including the ad hocs and permanent arbitration centers. Paradoxically speaking, we used to think that the more young people would be interested in arbitration, the more arbitration clauses would be listed or added to contracts, resulting in a growing number of arbitration cases. Unfortunately, no such steady growth has been noticed. The question is why. There has been a crisis in minor regional courts, which have seen a great drop in the number of cases, several cases fewer each year. So we should probably promote regional arbitration more successfully than to date. Polish arbitrators get to be nominated to resolve international disputes outside of Poland rarely, and this is the result of a lack of proper activity abroad. Too few Polish arbitrators take the floor at international conferences or publish their articles in international journals. Our visibility in the arbitration community, which is highly competitive, is decisively inadequate. Ladies and gentlemen, the experience of Polish arbitrators that I depicted for you might have been overly pessimistic, but I wanted to be a starting point for our discussion, and I think there have been too many conferences, frankly speaking, that presented arbitration as a bed of roses. It's time for us to reflect, and an in-depth reflection is welcome, especially that we are gathering here amidst friends and colleagues who are familiar faces to one another, so we can be candid and honest in our critique. We could jointly think of what can be improved and how to avoid repeating our past mistakes, because it is in all of our favor to progress this field in the future. I'd like to wish you a fruitful discussion, and I am excited to have so many illustrious, eminent guests among us, willing to spend their time in these weird and turbulent times to see us, if not face-to-face, then virtually. I hope we will be able to see each other live, face-to-face, able to shake our hands and gossip over coffee on the most pressing matters. Thank you, and I wish you a great conference. Let me greet all of the participants of this timely conference themed Arbitration and Mediation under the current circumstances, progress or recession. The activity of the conference committee, in particular, its driving force, the most esteemed Mr. Brych, seem to indicate that arbitration and mediation will keep developing because the organizers have successfully coped with the situation and organized the conference online. things look pretty much similar with arbitration itself. Arbitration has rose to the challenge of the pandemic, and effectively so. My background is not that of international commercial arbitrator, but that of my own experience as an arbitrator of the Ukrainian Chamber of Commerce and Industry. It is my duty and obligation to state that arbitration seems to have coped with the obstacles of the pandemic. It seems astonishing to witness how efficiently arbitration has adjusted to all of the restrictions adopted by the governments due to the coronavirus pandemic. It probably lies in the very nature of arbitration that its nature prompted it not so much to a new era, but to a new stage, a new level of arbitration, one that is more modern and better equipped technologically. So I'm sure that once we combat the coronavirus successfully, arbitration will change. First of all arbitration institutions have declared their openness to resolving business disputes under the circumstances. Second of all of the arbitration principles and regulations will remain binding. Arbitration institutions, including the International Court of Arbitration of the Ukrainian Chamber of Commerce and Industry, continue to rule in all cases affected by the coronavirus, taking all the necessary exceptions. So we have adjusted to the situation, and these adjustments are tied to the proceedings and implementation of new technologies in these proceedings. These technological facilities had been part and parcel of many arbitration institutions, including the Ukrainian ones, but these recent restrictions have additionally prompted arbitration to make the best of the opportunity which the situation presented with regard to new technologies. We have come up with and disseminated our recommendations on arbitration proceedings under the pandemic. The first recommendation was to advise adjudicating panels and parties to file all claims and documents electronically. We further advised to adjudicating panels and parties in disputes to employ the following dispute resolution mechanisms, although, to be honest, initially we were indeed in a state of shock after the imposition of different restrictions across the globe. We had to postpone a dozen or so hearings from April onto further months, but having cooled off, we witnessed that the other arbitration institutions did proceed with their hearings, and we came up with regulations that were welcomed by both arbiters and parties in Ukraine. If we set dates for hearings as per schedule, we still recommended all the parties involved in each individual case to determine the adjudicating panel and to obtain all consents from the parties for conducting hearings online, which we were mostly successful at. And right now, almost every hearing in Ukraine, both those between the parties and between the parties and arbiters, take place online. Moreover, we had a case in which We advised to hold virtual hearings not only with reference to the Ukrainian Chamber of Commerce and Industry and at its seat, but also in any other venues as agreed upon by the parties, so you can do it remotely. And if these video conferences were not satisfactory to the parties, our regulation stipulates that we can also suggest written hearings if the parties so desire. I would like to stress one feature here. In most of the cases, the parties were not only considerate of these novel solutions that we implemented, but were firmly supportive of and active in the organization of those video hearings. Although, if I'm to be objective, I have to state that we have had cases in which these novelties were not so actively and eagerly embraced. Even still, I think that we are entering a new era of arbitration proceedings with a special consideration of online hearings and online proceedings as such. I think that the remaining arbitration institutions, including ourselves, are all thinking about establishing an online platform in which the defendant will be able to apply for postponement of the hearing, and we will have to follow suit in agreement with our new working regulations. These novel solutions that I have listed had been in place before the coronavirus, but right now they have been used more extensively, and we are entering a new stage of arbitration based on online hearings and virtual technologies. As I said, other arbitration institutions also consider establishing an online platform for the sake of virtual resolution of dispute. This seems to be the future of arbitration, and I think this scenario is unavoidable. Moreover, we have seen many law firms coming up with sets of recommendations on conducting such virtual online hearings without violating the rights of either party and enabling the adjudicating panel to efficiently and objectively rule on those cases. It seems likely that this objectivity, our striving towards it, must be calm, must be even keeled. We need to move forward, and we need to appreciate these circumstances as they are a blessing in disguise of sorts. The limitations implemented due to coronavirus have gave us a spark in terms of moving on with the modern technologies. We are at the brink of a new era in arbitration. All of the adopted restrictions expedited the development of digital technologies. Obviously, there are certain legal and factual issues to clear before we move on. For instance, how to corroborate the identity of a stakeholder participating in the hearing, how to state whether they are the party itself or their proxy, and how to obtain permissions from the parties before we proceed with the hearing. For instance, whether we have to obtain such consents from both parties, and how to regulate these aspects. I think that in time, our practice and the development of technologies will enable us to address this issue more swiftly and efficiently and address it through a set of appropriate regulations. This concerns not only digital hearings, but also digital circulation of documents as such, and the entire procedure from filing a claim to the decision and ruling, including all communications in between. All of this takes arbitration to a whole new level, and even though it's not anything entirely new, it might give us a great boost. So I think that against all circumstances, arbitration has been blossoming under the coronavirus, taking this as a chance to elevate its quality to a new level. I am surprised to see not only our Court of Arbitration of the Ukrainian Chamber of Commerce and Industry, but also other institutions taking a very proactive role in not impeding the progress of arbitration, but aiding it, because this progress is unavoidable and it will be in the service of arbitration itself for as long as there are disputes to be resolved on the international arena. Obviously, we have observed a stagnation in international trade and commerce, but this is not equal to a possible stagnation of arbitration. Against all the odds, the crisis situation in our economies often tend to give a paradoxical spark, especially following economic and financial upheavals, and therefore translate into a multiplication of commercial cases. This is an observation that is not only subjective based on my perspective, but also objective. You can see it in Ukraine, where parties struggle to secure funding and therefore resort to arbitration and its measures. Personally, I do not foresee a huge avalanche of new cases, but nonetheless, 6 months from now or a year from now, we will be able to discuss it in detail. To conclude, I'd like to state that the current circumstances have prompted arbitration to seek new measures and new methodologies of solving disputes based on proven arbitration principles and without their violation, which helps arbiters to effectively resolve commercial disputes. And this cautiously optimistic prognosis seems to be relevant because it is grounded in the current reality of international trade. I'd like to thank you for your attention and wish you all great health and many a success in the future.
Good afternoon, ladies and gentlemen. Thank you very much for the invitation. My name is Laszlo Kecskes. I'm a professor of law, teaching civil law, private international law, and European law at University of Pécs. This is the oldest Hungarian university. It was founded in 1367, 3 years later, as the famous Krakow University. I think back, the first arbitrator whom I ever had seen in my life was a famous Polish professor of law. We had very close links and cooperation with the Krakow University, with the law school. And once, with one of my colleagues, I paid an official visit for 2 weeks to Krakow, to the law school. And there were two famous civil law professors. They were very, very highly respected in the academic life also. One of them was Professor Vladika, the other was Professor Skamsky. Vladika was very, very well known internationally. That time he was the expert of contract law. He used to be in the building of the faculty, almost always. Professor Skamsky was there very rarely. When we checked the colleagues about him, the answer was always, he is in Warsaw or somewhere in a foreign country because he is an arbitrator. That time I did not know what arbitration is all about, but I knew that being an arbitrator is something very exciting and it requires a very active life. So this is what I learned from Professor Skamsky, who was the first arbitrator whom I ever have seen in my life, as I thought. Well, how did I get in touch with arbitration? I spent 5 years in the government after the political changes between 1990 and 1995. I was a Deputy Secretary of State in the Ministry of Justice. I was responsible for draft making in the field of civil law, economic law, and I was also responsible for our negotiations with the EU. That time we negotiated our association agreement, so the harmonization of law, the approximation of law was also an issue in my field. I was the draft maker of the first comprehensive arbitration law in Hungary. This is the 71st Act of 1994. This is the so-called Old Arbitration Act, as now we have a new one. It was very, very much based on the UNCITRAL model law of 1985. And on the basis of this law, I think that arbitration was very successful in Hungary. So arbitration started on a legal level, on the basis of this act in 1994. Mediation started a bit later. The first act on mediation was our 55th Act of 2002, and later several times this mediation law was modified. Thinking of the relation of arbitration and mediation in Hungary during the development of the Hungarian legal system, mediation and arbitration were very close to each other. Arbitrators and mediators were in a very, very close relationship. The first Hungarian arbitrators during the Middle Ages were also mediators, so mediator-type persons. So it was very tough to distinguish between the two professions, if I may put it in this way. Despite that, arbitrators used to arrange their official administrative duties through state courts, through the administration of state courts. But their activity was rather mediation-like. The golden age of arbitration in Hungary was in the first part of the 20th century, in the 1920s and the 1930s. That time the ad hoc arbitration was the main part of the arbitration activity. There were some professions which organized their permanent courts, but the the main point is that ad hoc arbitration was the mainstream in this activity. Very, very famous professors were the arbitrators, and it's very interesting in these golden ages. There was an organization which was established in 1933, the so-called Arbitration Center. It was not an arbitration code, but this center gave methodological advices to the arbitrators if it was needed. After the Second World War, between 1949 and 1991, of course, the Comecon feature was determining, it was a Soviet type arbitration, as all of us know about this epoch. And but arbitration was successful, especially after the coming into force of our first arbitration act in the middle 90s. We had quite a few cases annually. Our caseload was well above 300 usually, so it was the figure of the new cases each year. And nowadays, I may say that there is a very obvious crisis in Hungarian arbitration. During the course of the last decade, arbitration in Hungary got two hits. It was hit twice. The first hit was caused by an act, the Act of 196 of 2011, which excluded state properties and self-government properties from arbitration. This law followed the philosophy of the famous Calvo doctrine. Carlos Calvo was an Argentinian professor of law and famous diplomat, expert in public international law also. I don't mean that the draft makers of this law knew who Carlos Calvo was, and probably they did not know his philosophy, but it was a very direct exclusion of the other jurisdictions, because only the Hungarian state courts were eligible to proceed in the legal cases of the foreigners. Of course, the foreign parties were not satisfied with it, and it was the reason why, after 3 years, a bit more as 3 years, Act 7th of 2015 changed the law and restituted the earlier situation. Very probably the foreign parties, the foreign trade partners of the Hungarian enterprises and the Hungarian state forced this change because they did not want to come to Hungarian state courts, and they insisted on the arbitration possibility. So on the 19th of March 2015, the earlier situation came back. We were very satisfied with this change. We were very proud of those efforts what we made, and we had the feeling that we were successful that time. But another hit came in 2017, when this so-called new arbitration code destroyed the earlier system. It was the 60th Act of 2017. It destroyed the earlier system, the earlier successful arbitration. It placed the framework of Hungarian permanent arbitration on new foundations. This law dissolved the earlier permanent courts like the Permanent Court of Energy, the Permanent Court of Securities and Financial Law and the Stock Exchange. And these two earlier permanent courts were put to the structure of the Permanent Arbitration Court attached to the Hungarian Chamber of Commerce and Industry. This conglomerate was the new permanent court in Hungary, and it was called also, even by the law, as the Commercial Arbitration Court. The terminology swaying, sometimes this terminology is applied at Commercial Arbitration Code, other times the Permanent Arbitration Code attached to the Hungarian Chamber of Commerce and Industry, so the terminology is swaying. And the original plan was to have the Permanent Court of Chamber of Agriculture also within this framework, but this chamber was stronger in the political decision-making field as the Hungarian Chamber of Commerce, so they could keep their independence. So it's a separate permanent court now, and of course the sports arbitration court is also a special permanent court. What are the main problems? The first problem is that these two independent arbitration courts, permanent arbitration courts, the sports and the agriculture, these are compulsory arbitration courts, which means that these are not real arbitration courts, as the parties have no freedom to make their choice and to make their own decision to participate in these processes. So if the judgments, the awards of these permanent arbitration court get a international nature, if these have a cross-border nature, in this case there could be very serious problems with the acknowledgement and the execution of these awards. This conglomerate, this organizational conglomerate, the Hungarian Commercial Arbitration Court, here the problem is that the carrying organizations are not interested in managing, in running these arbitration courts, because it's not a good business nowadays. The arbitration as an activity, the institutional arbitration, is very much down in Hungary. We have to keep it in mind. However, the plan of the new Arbitration Act was to make the first steps towards increasing the competitiveness of arbitration in Hungary, but the result was just the opposite. Earlier we had more as 300 cases usually. Last year this arbitration court, and we have to count the caseload of all the three earlier arbitration courts, the number of the new cases, the new claims, was 67. This year the result is even worse. Until now there are only 30 new cases at the National Commercial Arbitration Court. There are some very strange solutions in this rules in the Act. It introduced a very new institution, the retrial. it's an alien body in the set of rules of the arbitration. Maybe somebody wanted to change one word earlier, and it was the reason of introducing this institution, but it was not applied yet in Hungary. I have to make it clear. There is another very strange rule, namely that the presidency of the arbitration court is eligible to issue recommendations to the arbitrators. How is this? So it breaches the independence of the arbitrators. It's very inconvenient. It's very dangerous also. And the other thing is that one of these arbitration courts, these earlier permanent arbitration courts, the arbitration court of the stock exchange. However, they have a place within the presidency. The representative of the stock exchange is not willing to participate in the work of in the activity of this presidency. So it's a very, very strange conglomerate which came about as the consequence of this new act. So, as a general criticism, what's the reason of this current situation? I think that arbitration, the good arbitration activity, requires an equilibrium system as a basis. Equilibrium preconditions are needed. Thinking of the relationship and the equality of the parties have to be approximately in the same weight of the economic power and the sociological status also. If it's missing, then there is a problem with the arbitration and it cannot be successful. And the other main problem is that if the attorneys, the law firms, don't operate on an equilibrium structure, there should be equality among the participating lawyers, attorneys, and law firms. It's very, very disadvantageous and dangerous if 2 or 3 law firms capture the arbitration court, the administration of the arbitration court, and the activity and the management of the arbitration court. So my conclusion is that in Hungary, right now, it's obvious that there is a significant recession in institutional arbitration, and there is a modest development in ad hoc arbitration, and there is a more obvious but modest development in mediation. We have to clarify the relationship of mediation and arbitration. It's important to emphasize that from anthropological viewpoint and also thinking of the elementary way of thinking, mediation is the first and arbitration is only the second comparing to mediation. Arbitration is only a derivation of the mediation. So now when we are thinking, and this is my advice, my plan, that we have to think of a brand new law, a brand new act about alternative dispute resolution, which covers the legal problems of mediation and arbitration also. And I hope that on the basis of this new law, which is only a dream now, a better system of arbitration and mediation can come about here in Hungary. Thank you very much for your attention.
Ladies and gentlemen, distinguished colleagues, first let me to introduce briefly myself. I'm Alexander Belohlavek from Prague, Czech Republic, professor of international law and professor of international economics, attorney at law, arbitrator, past member of the World Jurist Association in Washington, D.C., also past member of the ICC International Court of Arbitration, currently Vice President of the Permanent International Court of Arbitration at the Commodity Exchange. I first like to express my gratitude, and I'm very honored to be invited to this fora and to share with you some of my thoughts regarding the current situation in arbitration and the task of arbitration in respect to the very specific situation we are confronted currently with. Apart from the obvious practical challenges concerning the needs to adapt to various restrictions imposed by national governments as a result of the coronavirus pandemics, the arbitrators will likely be confronted with a large number of qualitatively completely new cases. The current situation severely interfered with the performance of ongoing contracts in almost all business sectors. What's new is the dynamics of the disputes, which differs from the cases the arbitrators are usually faced with. Here, the existence of fortuitous circumstances and how the governments responded to them will be in the center of the disputes, rather than intentional breach of contracts. The parties are likely to rely, for instance, on hardship clauses or force majeure arguments, which will be rebutted by pacta sunt servanda, rebus sit stantibus, or similar principles. The tricky part is that, unlike in other cases, both parties might be affected and will claim circumstances exonerating them from the liability for the breach of their obligations. Of course, the governmental restrictions and their effect on the objective ability to perform the contract will be tested. All that will have to be assessed, taking into account the terms and conditions of the contract that might stipulate rules governing the existence of or exempting from liability. However, it is to be expected that legal arguments used will far exceed the mentioned principles. These arbitral tribunals will be under pressure to prove to the public, which has been for some time confronted also with negative publicity concerning arbitration, that the so often mentioned advantages such as flexibility and expediency are real. The circumstances of the past months are so extraordinary that a strict adherence to the contractual terms and conditions won't be simply sufficient. The focus will have to be on the foreseeability and reasonableness of the parties' actions, including their duty to prevent and to mitigate losses and damages, as well as on proportionality and necessity of the measures taken by the governments. As already announced by many major companies, they will seek compensations based not only on contractual liability, but they will involve also the responsibility of the governments by putting into question their response to the pandemics. Jurisdictional issues and questions regarding arbitrability will have to be dealt with. in a way, I believe that this situation also presents an opportunity for the arbitral community to show that the arbitral community and the arbitration is better equipped to deal with situations such as this than probably the national courts do. While respecting the rule of law, arbitrators should provide the parties with dispute resolution that is fair and just and takes into account the interference by the state and the parties had to endure. Considering the resources and technical possibilities available to the arbitrators, I hope that we will rise to the challenge and that arbitrators will be able to contribute at least partially to the resolution of the difficult situation of many entrepreneurs and companies. However, let me also to point out some procedural issues. Historically, as arbitration provided a tool of effective, fast and private resolution of disputes, where there was a threat that national courts will not be able to promptly and accordingly comply with needs of disputing parties. Core values of arbitration are on one side providing sufficient freedom to disputing parties while preserving seriousness and credibility of the proceedings, and providing expertise, experience and flexibility of arbitrators, while allowing also them to fully assess all relevant circumstances on the other. Almost 30 years of my practical and theoretical insight look into arbitration probably allowed me to witness many changes, tendencies, development, but of course also, unfortunately, steps back or steps, as from my point of view, in the wrong direction. Although it is my true and deep belief that arbitration should never give up on one of its major advantages, which is, among others, flexibility and the ability to provide parties with prompt but relevant and just award. Aspect of maintaining credibility and seriousness of the proceedings needs to always be taken into consideration. The word of our 21st century is without any doubt a word of rise of technology and globalization. The ability to reach others within a blink of an eye is something we as humanity couldn't imagine 10, but most probably not even 5 years ago. As this progress in many aspects is certainly positive and indeed appreciated, it is my belief that we should not approach it light-headed, and the adjustment of the institutes created many years ago to today's world should be made with caution and with respect to the core values of arbitration. Let me connect these thoughts with my experience from the last 30 years. Even though technology indeed made it possible for the parties to submit all documents electronically and even made it possible for the parties, arbitrators and other participants in the proceedings to sit in front of web cameras and to hold proceedings online with all the seriousness. I can say that I have learned that it is the possibility to feel the atmosphere in the hearing rooms, to shake hands with the parties, to look the person in the eyes, to see the mimic reaction of the parties, their body language, to be able to promptly react on anything that is happening in the hearing rooms. That is integral part of decision-making process, and that is something without which the arbitration would lose touch with its rules and core values. Recent global circumstances caused by the pandemic of coronavirus, as certainly and without any doubt hurtful and horrifying as they were, gave all of us opportunity to rethink and question our methods and ways. As for someone who is used to travel on a daily basis, it has been a time of unprecedented slowing down. Work, including work of arbitration, had to find ways how to carry on. I have seen and welcomed certainly many initiatives that could possibly outlast those hard times and lead into innovation even after recent events will hopefully become over. Yet I couldn't ignore the thoughts that despite the opportunity to innovate and progress, we should simply not forget our history and the core values, as I have mentioned, for only 3 with solid roots can grow tall. I would not dare to say that we should lock ourselves in a conference room, pretend that technology does not exist, and wait until arbitration gets obsolete and not suitable for latest demands of both parties and arbitrators. I believe that it's my role as a person with hopefully same experience to point out, or more precisely to offer my point of view. I believe that time may and most likely will come when technology will be able to supplement all that is so essential for arbitration, including all I have mentioned. But at this point, I must appeal on the arbitration community to sustain what's so inherent to meet what arbitration means. But let me also to point out an issue that weighs on me since many years as active arbitrator. This is the fulfilling of the main advantages which will be mentioned in the introductory part of almost all textbooks and treatises on arbitration. The speediness, expertise and cost efficiency of arbitration. The fulfillment of these prerogatives of arbitration will be all the more expected by the parties right now. Many companies and entrepreneurs have come to the brink of economic collapse. That's why they will expect a resolution of their disputes, not within 1, 2 or even more years, but within few months as maximum. It will be a matter of their survival. Parties will not expect to elaborate on hundreds pages long submissions, extensive expert opinions, long, weeks-lasting hearings, documents production, extreme cost of the proceedings. The parties will expect that arbitrators will react immediately. For instance, that they will call for hearing immediately. Rather than drafting guidelines and documents, materials, how to handle specific disputes in the post-pandemic time and creating task forces for it, we will be faced with very specific disputes, and it is my opinion that it is the time to opt for and to return back to very, very proactive and even investigative role of arbitrators. They are the parties who are appointing arbitrators. They are the parties who are putting their trust in the particular arbitrator. Once appointing or nominating an arbitrator, the parties must rely on the high professionality of arbitrators. Subsequently, they must be the arbitrators tasked to decide on how extensive limits will be set for the parties. As of my opinion, in particular, the current situation is the right time to think about such measures, like to cut in a maximum extent the time limits, to think about a very proactive role of arbitrators in witness examinations, for instance, rather than to leave all the activity on the parties, to cut in a maximum extent limits for written submissions, not to admit evidently for the disputes not significant evidence, to call the parties that they will present their closing statements in the end of oral hearings verbally, and not by presenting their post-hearing briefs in written within weeks or even months after the oral hearings. I have to mention that I in person do remember that it was natural and it was a standard that the parties presented the oral hearings in the end of hearings, oral hearings. However, all that is nothing new. If you will ask any of our distinguished senior colleagues, arbitrators or senior professors, they will simply confirm that this is something which was a standard of arbitration a couple of decades ago. Even extraordinary, complicated cases have been resolved within a couple of months, even weeks within one-day oral hearings. Many people may argue that the world became complicated and that the disputes are significantly more complicated than they were in the past. Might it be? Even it is certainly not possible to generalize, and all the less to use such very generalized and, from my point of view, alibistic and in many improper arguments for justification of living the basic principles of arbitration. Nevertheless, the principles of arbitration didn't change at all. Principles of arbitration, which I have mentioned, and which are part of each textbook currently, are completely the same as we could read them in the textbooks published 50, 60 or even more years ago. And we have simply to return to the origins and to the methods and conduct which created arbitration as a recognized and generally accepted tool for resolution of disputes preferred by the broad international business community. We have simply to return to the origins. Just one example. Many national laws on arbitration and even rules of permanent arbitral institutions containing rules on time limits for rendering a verdict. Often there are just a couple of months time limits. Naturally, such laws and rules contain also mechanisms how to extend such time limits. However, it is obvious and logic that legislators intended such mechanisms to extend the time limits as exception. And the parties expect that the proceedings will comply with such laws and rules when entering arbitration agreements. Nevertheless, the daily practice became completely different. Exceptions became a daily practice. This indicates, at least for me and certainly for many other practitioners I'm often discussing these programs throughout the years with, that the practice is moving away from expectations of the parties. The practice is moving away from basic principles of arbitration. The only way is, from my perspective, is that arbitrators will play significantly much active role in arbitral proceedings then it became a daily practice in the past years. And this is exactly what the parties will expect now, particularly now. And this is what the parties will call right now for. Arbitration and arbitrators simply must meet these expectations and significantly adapt and change conducts of proceedings from their perspective to meet their basic duties, to meet the tasks and aim of arbitration, in particular in this specific and indeed exceptional situation. Ladies and gentlemen, distinguished colleagues, thank you for your attention. Thank you once more for inviting me to this conference, and wishing you, of course, to remain healthy, and wishing you all the best. Thank you.
Dear colleagues, greetings from Moscow. My name is Dmitry Davydenko. I am an associate professor at Moscow State Institute for International Relations, MGIMO University, also the executive secretary of the expert council of a commission for arbitration of ICC Russia, and the director of CIS Arbitration Forum, which is an online project involving people from many jurisdictions of Eastern Europe and dedicated to dispute resolution considering parties from the region. Today, I will speak about case law on force majeure and hardship in international commercial contracts. The case law of international commercial arbitration tribunals under the rules of ICC, also from some other arbitral institutions, and from state courts sometimes. It is well known that the pandemic resulted in a large-scale economic turbulence, and the importance of it is not to be underestimated. This is clear. What does this what is its result as regards international commercial contracts? The debtors are very likely to invoke impossibility or impracticability of fulfilling their contractual obligations. They are also likely to refer to unexpectedly burdensome performance of the contract caused by restrictions on trade and movement of persons, on economic crisis, price fluctuations, and similar circumstances. Regarding this, it is already possible that such legal concepts as force majeure and hardship can be applied sometimes as a regular rather than an exceptional remedy. However, as we may predict, it is possible that many arbitration cases will likely involve force majeure, hardship, or similar arguments by respondents. We should consider the purposes of legal regulation in this regard while applying these concepts. One of the purposes is to ensure a balance between stability and flexibility in contractual relations. Another one is allocating the risks which derive from the pandemic. The risks should be allocated equally between the businesses, however, of course, always considering what is specified in the contractual obligations and the applicable law. Another purpose is restoring economy from the crisis and preserving legal stability. So the dispute resolution should be economy oriented and not aggravate the chaos, but help to overcome the crisis. This is, in fact, what follows from the existing case law on force majeure and hardship and similar concepts in international commercial arbitrations. Of course, applicable law matters very much and differs. The same concepts have various content in different jurisdictions. However, there is still a common denominator, and this is the UNIDROIT principles, force majeure, Article 717, hardship, Article 622, and the CISG, Vienna Convention on International Sale of Goods, Article 79, about the impediment beyond the parties' control. Similar principles have also been formulated by national courts in various legal systems. So, summing up the existing case law, the following approaches have been applied. As a rule, a debtor can be released from liability only if at the time of the conclusion of the contract the impediment to its fulfillment was not foreseeable, and this impediment or its consequences could not be avoided or overcome. The debtor has to prove that he did not assume the corresponding risk, which also follows from the text of the contract. As the arbitral tribunals in the ICC cases confirmed, the debtor may argue that he did not predict the extent or the period of existence of the impediment. So this is particularly acute with regard to the pandemic, that the extent and the period of existence was not predictable. As regards the parties' arguments about a burdensome performance of the contract, each party should bear the risk that performance of the contract may become more burdensome. For example, the buyer bears the risk that the market price of the goods drops down or that the goods will lose their value. And the seller, on the contrary, bears the contrary risk that the price will increase or that the cost of purchase and manufacture of the goods will increase. If there is a lack of money with the party, this as such doesn't relieve it from contractual liability. An interesting case was heard by House of Lords when this was the highest legal judicial instance in England. In case Sakiroglu and Company Limited versus Nobly Thorough Gesellschaft mit beschränkter Haftung. A military conflict blocked the use of the Suez Canal. The goods were to be delivered from Sudan to Hamburg, and the seller argued that now the delivery has become much more expensive than it was expected. The House of Lords, however, decided that the inability to access the channel does not make the contract unenforceable, that this is just a risk which the seller bears, that the performance may become more expensive. And the same rule usually applies when the performance becomes unprofitable or more complex for a party, but in principle practicable. So, since the contract did not provide it otherwise, this rule was applied. There are possible exceptions. If there is an extraordinary depreciation of money or extraordinary increase of the seller's expenses, and especially when the payment, for example, in a foreign currency is prohibited by a state act, but payment by any other means is also impossible or unreasonable. Having said this, the principle of good faith applies. An economic downturn as such does not amount to force majeure event. Economic crisis doesn't constitute such event. This is also usually considered in practice to be an ordinary contractual risk. In case Cessna Finance Corporation versus Gulf Jet, the legal limited liability company, versus Gulf Jet Limited Liability Company, ICC case of 2014. The buyer argued that economic downturn, market changes, lack of financing fall within the scope of the open clause on force majeure, which said, and any other reason beyond reasonable control. However, the arbitral tribunal interpreted this clause so that other examples in the clause had nothing to do with economic difficulties, market changes, and like this. So only if the economic risks are expressly indicated in the contract, only this event they release the buyer. The same approach was exercised by UK state courts in case Tandrin Aviation Holdings Limited versus Aero Toy Store LLC and other. Another important case is Global Tungsten and Powder Corporation versus Lago Resources, ICC case 2011, where the supplier referred to the fact that drought prevented him from making tungsten concentrate because there was no water available. The water was available, but the buyer needed to bring it by trucks at the distance of more than 100 kilometers, which was extremely expensive. And the court, the arbitral tribunal, found that it was unreasonable, and this is what was beyond the reasonable expectations for what should be expected from the seller. Force majeure event, as the practice shows, is over when all restrictions are removed. The extension of the period for fulfillment of obligations may be longer, however, than the duration of the impossibility of performance, which is also as acute as regards the crisis. Because it is, as the arbitral tribunal confirmed, the party needs and may be granted a certain time period to restore its business operation after the removal of force majeure event. In that case, just 3 days. for renewing transportation of gas through the pipeline after the restrictions were over. If there is still a small probability of new restriction, this doesn't count, and in that case the restriction was less than 1% probability that the new restrictions will be introduced. As my time in this speech is limited, the last point which I think should be made is that hardship under the unidroit principles and in many legal systems allows the party sometimes to renegotiate and adapt the contract to the changed circumstances to restore the equilibrium. This is what can be done successfully by arbitration. The arbitrator can be the person, or the arbitral tribunal can be those who will help the parties to adapt the contract to new circumstances, or other ADR such as mediation, expert determination. So in this time, such remedies or such ways of dispute resolution, I think should be considered by the parties in order to deal with the changing circumstances. Thank you for your attention.
Good morning or good afternoon, depending on your time zone. My name is Vladimir Khvalei. I'm partner at Moscow office of Baker McKenzie and also the chairman of the board of the Russian Arbitration Association. And I use this opportunity to talk to you about arbitration in Central and Eastern European countries. In particular, I was asked to speak about the condition for arbitration and mediation, development or recession. In order to understand whether indeed there is a problem today with development of arbitration and mediation, I'll be mainly talking about arbitration because I think it's difficult to get statistics with regard to mediation, especially reliable statistics. I'd like to show you some numbers which are related to Poland and to some other countries, and then based on these numbers we will understand whether arbitration is in good shape or it's in a bad shape. I'd like to start with Court of Arbitration at the Polish Chamber of Commerce. Here I've collected some statistics, including with some assistance from Piotr Nowaczyk, who kindly provided me with some numbers. If you look into the case number at the Polish Chamber of Commerce, you will see that in the 80s of the last century, there was a significant number of cases at the Polish Chamber of Commerce, 750 cases, dropped a little bit after that, but you all see clearly the line declining. My understanding also that this number of cases include also domestic cases. This is not only international cases, also domestic cases, but from other sides, still the numbers are pretty representatives in order to understand the general tendency. So we'll see the number of cases is declining. Then there was some raise in 2009, 2010. This is, I believe, due to the crisis of 2008, 2009. And then after that, again, the number of cases is declining. In 2019, there were only 120 cases. So there was a pretty significant drop of arbitration cases at the Polish Chamber of Commerce. If you look into proportion between international and domestic cases, you'll see that the major part of these cases are domestic cases. There are international cases, but again, the number of international cases is declining, as well as number for domestic cases is also declining. I also look into statistics of the other Polish court, Leviathan Court of Arbitration, and we've got information about case filing and awards issued. And as you could see, this arbitration court started 15 years ago with one case, and now it has around 50 cases. But what is interesting, there's no general tendency of declining of number of cases. The number of cases for the last 5-6 years is pretty flat and not declining. If you look into statistics of ICC Court of Arbitration in cases involving Polish parties, you could also see that generally number of Polish parties in ICC arbitration is increasing. The number of Polish arbitrators sometimes is higher, sometimes is low, but there's still significant number of Polish arbitrators in ICC arbitration. If you look into Czech Republic, the statistics is pretty interesting because there's also significant raise of cases in 2010, 2009, again representing after crisis situation. But after that, there was significant, even more than in Poland, drop of cases in Poland. And one, of course, could ask himself or herself why number of arbitration is declining. So we see in the market less and less arbitration cases. If you look at the Russian Chamber of Commerce, in Russian Chamber of Commerce, you see more or less the same tendencies. You see some raise of cases in 2009 and 10 due to crisis, and then there was, for some period of time, the number of cases was flat, and in recent years, we also see declining line of cases. The same tendency in Ukrainian Chamber of Commerce, although the number of cases dropped in the last 5 years significantly, from 922 cases to 243. But my explanation of this significant drop is that there are two basic reasons. One is crisis in the eastern part in Ukraine, and less contracts and less disputes with Russian Federation. From other side, Ukrainian arbitration cases were number of Ukrainian arbitration cases were pretty high for a pretty long period of time because there was a special regulation under foreign currency exchange law which encouraged the parties to start arbitration in order to avoid penalties accrued because of breach of currency regulation. And now this regulation has been not completely abandoned, but made it more soft and less severe, and this explains that there is less amount of cases at Ukrainian Chamber of Commerce. So if you combine together Polish Chamber of Commerce, Russian Chamber of Commerce, and Ukrainian Chamber of Commerce, you see significant decline of cases in recent years. From the other side, if you look into leaders in the world of international arbitration, you see the adverse tendency. At ICC Court of Arbitration, the number of cases is increasing, starting from 90s to the recent years. The same tendency you could see at LCIA, and the same, even more significant, at Singapore International Arbitration Center. So what we could take from it is that in Central and Eastern Europe, we see the number of cases declining, while at the same time, as the leaders of international arbitration, the number of cases are growing. So it's adverse tendency. At the same time, if you look at, for example, the Russian Chamber of Commerce, you will see that number of cases for the last 15 years is more or less flat, around 100 cases per year, which reflects that, of course, there is tendency in increasing the cases after the crisis of 2008 and 2009. But other than that, the number of cases is pretty flat. So you ask yourself, what happened with arbitration? Does it mean that the market for arbitration has shrinked, and we see less cases, or number of cases has grown, but the cases went to some other institutions and not in Central and Eastern European? I believe the answer is probably the second one. So generally speaking, the market for arbitration is growing. So globally, we see more and more cases, arbitration cases, and I think it is explained by the fact that more and more companies are involved in international trade. And we have more and more contracts, you have more and more disputes. It's inevitable. From other side, one needs to realize that these days arbitration market is highly competitive. And arbitration institutions are not behaving like state courts, just waiting for the cases to come to administer. Arbitration institutions are presenting themselves as commercial companies in terms of promoting themselves and marketing themselves. Big international centers, they have marketing departments. They organize various kinds of conferences, seminars, webinars. They're promoting their rules. They have users' councils. They're trying to attract more and more cases. And they're selling, in a sense, their service to international business. From other side, if you look into traditional, so-called traditional arbitration institutions in Central and Eastern Europe, unfortunately, they are not behaving in the same way. They're still operating in a little bit old-fashioned or old-school manner. Sometimes they have indeed kind of seminars on conferences where they explain their rules. Sometimes they're meeting with their users, but in terms of promoting their services, they are far, far beyond of their international competitors. And I'm afraid that if they do not change their behavior and would not start to operate in a changing world as a kind of a new player, not new players, it's not correct word. If you should not change their behavior, not start to market themselves as normally business entities do, then the number of cases could still continue declining. As a very sad and bad example, I want to show statistics of the Russian Maritime Arbitration Commission. You see that in 1993 they had 78 cases. In recent years, the number of cases dropped to 5 or 4. We also know that in Poland, at the time of Concon, there was also maritime arbitration court in Gdynia, which considered significant number of maritime disputes. But I haven't heard about this case for many years. I don't know whether the court exists or does not exist. What does it show you? That if arbitration institution believe that something which was done in the past will work forever, and the companies will nevertheless come to them to resolve disputes, it will not happen. Because people at companies are changing, new generation is coming, new generation of lawyers, they do not know what happened 20, 30 years ago, they do not want to know what happened 30 years ago, and they include arbitration clauses in the contract of those institutions which they see on the market, on the conferences of various institutions in which they have trust that they could properly administer the disputes. This is all I want to say to start this discussion, and I hope to get some questions. You can also look into very interesting interview which we had with Beata Gezel-Kalinovsky-Velkalish, as the honorary president of Leviathan for arbitration. It was done in the framework of Arbitration Kitchen, organized by Russian Arbitration Association, where we took interviews with various arbitration practitioners around the world. And Beata, in a sense, represented Poland. So she cooked mazurek, and also we had a very nice and interesting talk about arbitration in Poland, where she shared her view, what happened with arbitration in Poland and what could be done in order to change the situation. I hope it was useful, and I looking forward to get your questions. Thank you very much. Bye-bye.
I'd like to welcome the participants of the online conference. My name is Alida Mahmudova. I represent the Azerbaijani Mediation and Arbitration Center. I will speak about the perspectives of development of ADR in Azerbaijan. Today, the pandemic has affected all of us and has sped up changes in the global economy, which have dire consequences, and we are faced with unstable conditions which make it impossible to predict anything in the sphere of the economy. Very often this unstable situation brings about conflicts in society as well as in business. Under these circumstances, we need to have resort to effective ways of dispute resolution, which would be economical on time and money. As you know, Azerbaijan is rich in oil deposits, and in the current situation we have to adopt a new approach to the development of the economy. In order to jumpstart the economy, we need to improve the business relations through revising our strategic goals and adapting to the new circumstances. One of the ways to do that is to create conditions conducive to alternative dispute resolutions. Speaking about strategic aims, I have to mention the strategic roadmap of the national economy of Azerbaijan related to 11 sectors. This was adopted by the President of the Republic in 2016. Most of these are currently being implemented. One of the priorities of the strategic roadmap is to foster medium and small enterprises. Here we have priorities which improve ADRs between stakeholders. Among others, we want to improve our legislative base on domestic and international arbitration. Within the roadmap, we have envisaged the creation of a new institution of mediation, where we want to again create a new legislative base. Speaking about arbitration, this base mainly concerns the regulation of international arbitration in a country which has made everything in its power to foster regional and local development. The law on arbitration was adopted in 1999 on the basis of the model UNCITRAL law on international arbitration from 1985. At that point, this was just a blind reception of the proceedings of arbitration. Now, however, we need to revise the contents of the law to adapt it to the Azerbaijani conditions. We also want to remove some of the lack of compliance. The provisions related to the recognition of arbitration proceedings are enshrined in the Code of Civil Procedure. Azerbaijan is a signatory of the New York Convention of 1958 and also of the European Convention on International Arbitration of 1961, and of the Washington Convention on the resolution of investment disputes between countries. In November 2013, Azerbaijan set up an international court of arbitration, which has worked until now and is an independent legal body. As of today, this is actually the only institution that relates to international arbitration. In April 2008, in order to extend ADRs, a restructuring of this organization took place. A Center of Mediation and Arbitration in Azerbaijan was created. As for mediation in its classic form, this is a new institution in our country, one of the ways of alternative dispute resolution as a result of the implementation of the roadmap concerning the economy as far as small and medium enterprises are concerned. On the 29th of March 2019, a mediation law was adopted in line with international practice of the model rules of UNCITRAL and the relevant guidelines, which define the goals and purposes of using mediation. It also strengthens the approach of applying mediation and also defines the legal status of the mediators. As for the scope of use of mediation, it can be used in civil, commercial cases, as well as international family, employment, and administrative cases. The mediation law also enshrines in itself compulsory mediation sessions in prejudicial proceedings, and this obligation is going to come into force as of the 1st of July this year. The mediation process takes no longer than 30 years, and in the case of complicated cases, it can be extended by another 30 days. If the parties have concluded a mediation clause, the enforcement is binding on the parties. Let me add a few words on the status of mediators. According to the new law, a mediator in Azerbaijan can be any person who has become 25 years of age, has a university degree, irrespective of its major, with a 3-year job seniority and a certificate confirming the conclusion of a course. The law also envisages non-commercial organization to coordinate and verify both the mediators and other organizations that deal with the education of mediators. The Council also runs a register of mediators and determines the mode of disciplinary proceedings. Also, the Mediation Council in April 2020, a set of basic documents was adopted with a portfolio of a mediator, that is the invitation to the parties, a confidentiality clause, consent to mediation proceedings, the reform that is taking place in all areas to provide a sustainable growth of our country, caters not only for the economy but also for all the judicial proceedings, ADR included. This is confirmed by a regulation of the President of the Republic adopted only last year to extend the scope of legal practices, which obliges the Ministry of Justice to run education and awareness-raising campaigns on mediation proceedings in order to extend the non-judicial ways of dispute resolution. The Ministry of Justice and the Ministry of Economy were authorized to prepare a joint proposal on the support of effective international procedures of arbitration in our country. I would also like to draw your attention to one aspect envisaged in the regulation. This is the obligation of the Supreme Court of Azerbaijan to create a uniform judicial practice and mechanisms of enforcement to secure the stability of the approach of courts to the resolution of legal cases and to the positioning of courts with respect to mediation. This is one of the major aspects in the creation of uniform judicial practices as for the recognition and enforcement of international ADRs. In this way, currently, we observe a development of ADRs in Azerbaijan, first of all, thanks to the support of the state. To admit that ADR is not still fully used, mainly because we do not see the advantages of it. There is no popularization of this, and there is a lack of arbitrator and mediator. Still, we are aware of the benefits of the institutions of mediation and arbitration, which are supposed to develop in the following directions. First of all, we need to professionally prepare the arbitrators and mediators, and we need to create a professional group of mediators and arbitrators. We also need to extend and improve our legislative base, and we also need to adopt international standards of both ADRs, and we also need to popularize through the so-called roundtable. Thank you so much for your kind attention.
Good morning, dear colleagues and friends. It is a big honor and pleasure to be able to talk to you. We often hear and occasionally use the terms global and regional arbitral institute. In this short talk, I decided to critically address and revisit these concepts. Global arbitral institute and regional arbitral institute. What do we actually refer to when we use denominators regional and global? Are there any clear criteria for delineation between regional and global arbitral institute, and whether the pandemic might change our understanding of what is regional and what is global? It is always helpful to start with the dictionary or vocabulary meaning of the terms. So global means involving the entire Earth, or not limited or not provincial in scope. Regional identifies something relating to or coming from a particular part of a country or a particular part of the world. When used in opposition to each other, global emphasizes something unlimited and all-encompassing, whereas regional identifies something which is limited by a particular region. One, of course, can argue about regional being an advantageous, positive category, like a strong institution with a particular boundaries, which knows regional norms and customs and which is well integrated into a particular part of the world. However, when the two terms are used together, regional becomes a more vulnerable concept. For arbitral institute, global can be perceived as a clear competitive advantage, an institute with a global reach or unlimited in its reach. For arbitral institute, regional can be understood at the same time as referring to yet underdeveloped stage of the institute, which failed to achieve the global status. Who uses the terms global and regional nowadays? We may find regional in the official title of arbitral institutes, quite reputable arbitral institutes, like Tehran Regional Arbitration Center or Cairo Regional Center for International Commercial Arbitration. Some institutes used to have regional in their title, but no longer. This is the case for Kuala Lumpur Regional Arbitration Center, nowadays called Asian International Arbitration Center. By and large, however, arbitral institutes do not have or avoid having regional in their title. Despite of possible attractiveness, neither arbitral institute has global in its title so far I know. Though we may come across, of course, marketing description of the institute as serving global economy or as being the world's leading institute. Who introduces, who owns these categories, global and regional arbitral institute? Without aiming to be exhaustive, it might be helpful to look at the work of Alan Stone-Sweet and Florian Griesel, called The Evolution of International Arbitration, and which was published in 2017. These scholars name ICC, AAA, and LCA as being global institutes or global houses, arbitration houses, and they call SCC, Stockholm, SIAC, Singapore, and Hong Kong as being arbitral institutes with global aspiration. We might also come across the GAR Guide to Regional Arbitration, Global Arbitration Review, introduced in 2013. I should say, though, that no similar guide exists in relation to global arbitration, just to regional arbitration. And for GAR, Stockholm, Hong Kong, and SIAC, Singapore are regional arbitral centers. Now, what are the criteria that supports delineation between regional and global arbitral institute? Is that geography of the parties that choose the institute? Is that availability of local satellites? As we know, some institutes decided to open some representative offices in some countries, or otherwise show their geographical interest in some other regions where the place of their regional location. Is that nationality of appointed arbitrators or nationality of arbitrators in the list, if an institution has a list? Is that recognition of local peculiarities or local legal environment in which an institute operates? The most likely candidate, which lies on the surface, it appears to be the geography of the parties involved. Again, it is unclear what qualifies for the status of global and what deserves the status of regional. While ICC and LCA has parties coming from more than 100 of jurisdictions each year, those institutes which are marked by Stone-Sweet and Griesel as institutes with global aspirations, Stockholm, SIAC, Singapore, and Hong Kong, they have around 50 jurisdictions each year, slightly more, slightly less, depending on the year. This makes me think that there could be other arbitral institute, which might have the same spread of nationality as these institutes with global aspiration like Stockholm, Singapore, or Hong Kong, but which for some reason unknown to me are not referred to as such. And using this opportunity and aiming to combat some stereotypes, I would like to give some information on the institute called the International Commercial Arbitration Court at the Chamber of Commerce and Industry of Ukraine. And I'm a vice chairman of this institute, so I'm affiliated with this institute. It might be interesting to learn that the International Commercial Arbitration Court at the Chamber of Commerce and Industry of Ukraine had more than 50 countries involved last year. So it's the same level as for Singapore or for Hong Kong, and it is slightly more than Stockholm had last year. The institute has resolved more than 2,000 cases for the last 2 years, all of which are international. The institute is not engaged into settlement of domestic disputes. More than 90% of cases are considered up to 6 months, and more than 70% of cases are considered within 3 months after the constitution of composition of the arbitral tribunal. In my view, global and regional in the present stage of conceptualization doesn't give much as to the clear understanding of the precise role of arbitral institute. These categories, global and regional, does not capture the success among so-called regional institutes. All of them are under the category of regional, but some of them, like Stockholm, Hong Kong, Singapore, or my institution, evidence quite impressive success in being able to to attract confidence and trust from parties coming more than 50 countries. Finally, pandemic in its turn has made many arbitral institutes going virtual and online, and this, in my view, might change our perception in what is global and regional more, and we might experience in the years to come more or growing geography of the parties popping up in various parts of the world, in various institutes traditionally called to be regional. Thank you very much and enjoy the conference.
Ladies and gentlemen, this is a great honor and pleasure for me to take part today in this international conference, Arbitration and Mediation in Theory and Practice. It's always great to be in Poland, and that is why I sincerely hope that we will be able to meet in Poland in person next year. Today, I'm really thankful to the organizers for being able to take part in this conference online. And now I will continue my presentation in English. Thank you.
Today in my presentation, I will address the issues related to cybersecurity and data protection in international arbitration. Of course, none of them is new, especially in the light of the GDPR. But the pandemic influenced them significantly because almost 100% of arbitrations has become digital. Of course, the exchange of data, the transfers of data within arbitration are very significant. And any violation of the data protection regulations or any violation of data protection laws may potentially bring huge economic losses. And these losses may include high administrative fines, for example, the ones provided by the GDPR. That's why these issues should be addressed. But how are these issues addressed in international arbitrations? And are they actually addressed in the arbitration? Have you ever seen the contracts where you have the provisions related to data protection and cybersecurity in arbitration? The arbitration clause itself is usually called a midnight clause because it is agreed upon by the parties in the very end of negotiations when all other contractual provisions have been already discussed. And what about cybersecurity? Especially for some potential arbitration, we cannot even call it the sunrise clause because it almost never exists in the contracts. And that is a huge issue which arises in practice at different stages of arbitration, and even few times within one proceedings. For example, the recent case, which is currently actually pending before the PCA, the case between Tenant Energy versus Canada. And in this case, the issue related to applicable data protection laws arose two times. The first time it was related to the GDPR because claimant raised the issue of application of the GDPR because of the nationality of one of the arbitrators. And the second time, the issue of application of Ontario Privacy Act was related to the substance or to the meaning of the term confidential information. That's why this issue really happens in practice. We meet it in practice, and you can imagine how high the stakes may be, because if we talk about the application of the GDPR, you remember how high the fines are. Therefore, all these issues should be addressed in the international arbitration. Today, I will give you 5 tips, or better say 5 stages of actions which you should fulfill to address the issues of cybersecurity and data protection. So the first stage is data mapping. This stage is a technical one, and it is very familiar to you in case you have done the check for compliance of your company to the GDPR, for example. Because at this stage, you need to figure out which personal data and which data would be necessary for you in arbitration, in potential arbitration at that point. Which subject would you involve? Who will be the counsel? Who will be the potential arbitrator? Who can be the potential expert? Then you can see which data would be necessary for all of these participants to fulfill their functions within the arbitration. And then you need to figure out the directions of the data flows on this map. So you basically understand which data you have and what are the directions of data flows. This stage can also be called data due diligence. You can also involve a data analyst for this stage, so they can help you professionally to monitor, to figure out which data you have. It is normal practice for all of us to receive the legal advice on the potential outcomes of the arbitration cases before filing the notice of arbitration. And this due diligence, this data mapping should be equally important and should be equally normal for all of us before initiating the arbitral proceedings. Then the second step, the second stage, is a purely legal one. At this stage, knowing which data you have and who are the potential participants of the dispute, in which jurisdictions they are, you can find out which laws would be applicable to data protection for all of these participants. Let's imagine the usual arbitration, usual international arbitration. Normally, the parties, their counsel, 3 arbitrators, then arbitral institution, arbitral secretary, all of them are located in different countries. And if it is the case, it might happen that different data protection laws would be applicable to all of them. And the aim of the arbitral proceedings in this case is to fulfill the requirements of all the laws and all the regulations that are applicable to all of the participants. That's why the data mapping can help you to figure out which laws would be applicable. Here we can come back to the case between Tenant Energy and Canada, because in this case, there were 2 legal regimes that were discussed between the parties and the arbitral tribunal. And the arbitral tribunal had to make a decision which one is applicable, if it is a GDPR which is applicable, or if it is the Ontario Privacy Act. And in the end, in the conclusion, the tribunal decided that GDPR was not applicable and the Ontario Privacy Act would be applicable. So it may happen in the real arbitration, and it's a step that you should take before submitting the request for arbitration. Then the third stage, or the third step, which should be taken simultaneously with the second one. Because here you need to check the arbitration rules that should be applied, that you have agreed upon between you and your contractor. You can check these arbitration rules if they have any guidance on data protection and security, as well as any guidance given by the institution, if the institution has given this guidance. For example, the ICC, in its note to the parties and arbitrators, has given this guidance. So there are a few provisions related to data protection and cybersecurity. Moreover, in this note, the ICC refers to the ICC report on international technology, on information technology and international arbitration. And in this report, there is a detailed guidance on which measures should be taken by the tribunals and by the parties and their counsel in arbitration. Therefore, all these sources provided by the institution might be very helpful. Another batch of materials which might be also useful are the materials developed by the international associations. For example, ICA recently developed a few documents together with the New York Bar, for example. They issued the protocol on cybersecurity in international arbitration. And they issued it recently in 2020. So you can check it out. The second document, which is also very helpful, is the Seoul Protocol on video conferencing in international arbitration. So if you are using the video conferencing, then of course you should check it out. And then the third document, which has not been adopted yet, but which is currently being developed, it is the ICA-IBA data, the roadmap on data protection in international arbitration. And this protocol and this roadmap, it contains very helpful tips and very helpful pieces of advice how to deal with security and data protection issues in international arbitration at different stages. Moreover, this draft document contains the model documents which you can use for your own arbitration. It also has a checklist for your own arbitration, so check it out and keep an eye on it. None of these documents are binding for the parties. However, they give a very, very helpful guidance. So the fourth step is also close to the technical step. It is related to the platforms you are using for your document exchange and for video conferencing. When you have the map of your data and the data flows, maybe you can imagine which platforms you would use for your exchange of documents and for video conferencing. So go through terms and conditions of these platforms, go through their settings, and checking out how they work may help you to provide the secure use of this platform. For example, if you can set the passwords for your conferences or for your folders, then set these passwords. If you can send the passwords and the links to the folders and to the conferences by different emails, then send them separately. If you can switch on the end-to-end encryption, then do it, but check it before, because, for example, some platforms like WebEx, they have end-to-end encryption, but it's an opt-in function. And it means that you need to go to the settings just before starting your conference, then tick the box end-to-end encryption. And only after that, your conference would be end-to-end encrypting. So go and check all these technical regulations and technical standards. And the fifth step is basically the conclusion of the 4 steps before it. After gathering all this information, after understanding which issues should be addressed, you can apply to the tribunal for issuance of the data protection protocol or cybersecurity protocol. In these issues, you can address which laws would be applicable to the cybersecurity and data protection. In this protocol, you can address which obligations the parties have, what are the rules of document production, of filing, what are the rules and what are the actions in case of data breach. All these issues can be addressed in this protocol. Moreover, this protocol also helps to keep both parties and the tribunal informed about the issues of cybersecurity and data protections and measures that should be taken. Then second, the discussion of this protocol, the issuance of this protocol allows the parties to discuss which measures that they can take and how can help each other to comply with the requirements of the law in regard to data protection. Therefore, knowing all these issues and taking the appropriate measures to have the arbitration secure and protected, we can provide the necessary confidentiality and we can protect the data which we have in arbitration. But it requires the prior analysis of the data flows, the documents that regulates data protection and the documents that regulate the activity of the platforms. I think I will conclude right here, but I will be happy to continue the discussion a bit later. Thank you very much.